with him for the last few years now, and he is here today to do a, I called it a sensitivity training seminar, but he's going to be focusing also on harassment issues and touch on discrimination and talk about protected classes and also what we should do to make sure that each of us understands proper protocol and procedures. So if you have any questions, he really appreciates an interactive audience, so don't be shy. Plus, he's going to engage us even if we don't want to be engaged.
That's right.
So Jonathan?
Thanks, Pam. Good afternoon, everybody.
Good afternoon.
Thank you for being here. I know you had no choice, but I appreciate it anyway. It is a very important thing to do, and I do it for many clients, and I've been doing it for a long time. Just to tell you a little bit about me, I am an employment attorney, so that's all I do is employment law, and mostly represent management, meaning represent companies, and I am a litigator, trial lawyer, so I do, most of what I do, I would say, is litigation of some sort, and then there's a part of my practice where it's the trying to avoid, litigation, because I might enjoy it, and I went into this field because I thought it would be kind of, hey, it'd be fun, go to court, whatever. Not that I had any clue. No one does in law school. You think you do, Watching LA Law, awesome. Case can be tried in 12 minutes. It's so unrealistic. I don't even watch legal shows, but I don't think I've ever met a client who says, this is really fun. I'm so glad I was sued. And we're having a good time in court. I'm spending tens of thousands of dollars on you instead of my business. It's great. So my job, if I can, is to avoid litigation for my clients, even if, that's what I do so much of it and trained to do, and hopefully do it well. So part of that is talking to managers every day, talking to HR folks. Again, all I do is employment law, anything related to employment. I don't do anything else, nor would I. I have, and many years ago, and I kind of fell into this area of expertise because I think it's an interesting area. It's always changing. You're dealing with people issues, you're dealing with psychology, you're dealing with all kinds of interesting things, and some pleasant and some not so pleasant. And part of what I do is the counseling and the advising and the training when I do, and it's great when clients, I'll say, look, you maybe want to do a training like this at some point. I do different kinds of training, and this is going to be focused on a particular area of the law, and that really affects or may affect everybody, which is discrimination law. We're going to kind of fine-tune that into focusing on sexual harassment. And if I could get the next slide, Pam, and again, just to reiterate, please, if you have any questions along the way, interrupt me, raise your hand, whatever, because it's always better if it's interactive. So what you're seeing up there are called protected classifications, and I want to talk about this before I talk about sexual harassment law or your policy or whatever. And basically, what these categories are. Anyone want to take a guess of what that might be in terms of employment law? What do those things mean, if anything, to you when you look at those? Anybody?
Basis for discrimination.
Basis for discrimination. Well, and someone here said questions you can't ask and that's also part of it. So, certain things you can't ask about, for example, on a employment application or interview or whatever. That is because of discrimination laws, right? So, and it's because you can't use any of these bases as a basis to make a decision. Generally, I'm not going to get into stuff that doesn't apply to us, like affirmative action and things like that. But in general, you can't say, look, we want to try to make this place younger, so we're going to get rid of all of our 50 and olders. That's age discrimination, and that's illegal, right? I'm 49, so I'm okay. I'm not worried.
Next year.
Right, next year. So these other I'm sure you've seen it, right? Race, color, gender. You can't use the religion, physical or mental disability. Those can't be used as the basis to make employment decisions. Whether it's we're going to hire someone on that basis, or we're going to terminate someone on that basis, or we're going to demote someone, or that's where harassment, the whole area of harassment law comes into it. You can't subject someone to a hostile environment, on the basis of one of these things, one of these protected classifications, without potentially running afoul of the law. So I'm going to be talking mostly about sexual harassment today, but when I do, and particularly when I talk about hostile environment sexual harassment, which is one of the two types, you can keep these things in mind, that I could very well be talking about harassment on the basis of race or color or religion, or national origin. There are those cases out there. I have those cases. I've had those cases. So I do a lot of discrimination laws. Why am I going to focus on sexual harassment? A couple of reasons. One, it's still the most common form of illegal harassment. And also and because of that, there are laws that are specifically focused on sexual harassment. So they cover, the laws cover, illegal harassment on any of these bases or discrimination, but there are specific sexual harassment laws in, for example, Massachusetts and Rhode Island and, federal. And Rhode Island and Massachusetts have laws that are actually very similar to each other, that requires that you have every employer to have a written sexual harassment policy, that it says certain things in it, it defines and gives examples of sexual harassment. If you have a complaint, you want to make a report, here's who to go to, you have to say that, etc. So, and also encourages the training we're doing right now. Doesn't require it, but encourages it, and it's, in my view, a very good thing to do, because it's important to have the policy, and you read the policy, but it's, hopefully, I'll make some impression on you today, and you'll remember that and take it with you, and again, you have a chance to ask me questions or make comments as well. So, there are a number of these that we could spend a day talking about. I've given a whole seminars on disability discrimination law, for example, and reasonable accommodation and all that stuff. There's a lot up there, but, again, I'm going to just focus on sexual harassment. But just so you have an example, and so you understand this a little bit, if you harass someone because you don't like younger folks, you go, you know what, I just, if you're anyone under 40, I don't quite trust. They're not experienced enough. So we're going to give those people, we're going to put them through the ringer. Or you know what, I'm new to this about this company. Everyone under 40, you're fired.
Yeah.
Is that discrimination?
Yes.
Based on age? Yes. Illegal?
No.
Did you say no? No, you knew the answer. That's not fair. But no, as absurd as it is, okay, and it would be stupid, but it's to illustrate how not all discrimination is illegal, and not all harassment is illegal. I mean, you've heard of, and there are talk in Massachusetts about bullying laws, and whether in the workplace. I mean, there are some in public schools, those laws are in place, but should there be bullying laws in the workplace and all this stuff, which I think would really be good for my business. Like, it's crazy, but I think it would be great for business. In your policy, and there's going to be a new policy that comes out soon that I'm working on, a revised policy, but we don't want any harassment or disrespectful behavior in the workplace. And sensitivity trends is being sensitive, obviously, to your coworkers, and respectful in general. So that's here, but it doesn't mean that even conduct which might violate another policy or be inappropriate or disrespectful would violate your illegal harassment policy or even the law. So I just want you to kind of, just saying it to make those distinctions. The other thing you should know is that, the question you might ask is, well, which laws apply? Like, what if, federal law says this, state law says that, or Rhode Island law says this, Massachusetts says that? And that depends really where the employee generally is located, but if you are, let's say the question is, well, I'm in Rhode Island, and Rhode Island law says, that sexual orientation discrimination and harassment is illegal, which it does. So does Massachusetts. Federal law does not. which law do you have to comply with? Doesn't federal trump state? Federal government bigger than state government? What do you think?
Yeah,
I would think
Yes.
so.
Well, what would the point of Rhode Island having that law be then?
Right, exactly.
Whichever law provides more protection for the individual, that's what rules. In either direction, okay? So membership in the uniformed services, there's a law that came out after Desert Storm, this is '94, and it's a leave of absence law for people in the military. It's also an anti-discrimination law. And so not all states have that. For example, Mass doesn't. So, and I don't think Rhode Island does, but it's the federal law that we have to follow, you know, in that regard. That's the one that's gonna govern. So, and if, you know, federal and Rhode Island and Massachusetts, 40 is that age line, well, what if Rhode Island were 25? Then that would be the protected age. So why is it 40? Beats me. I should know that. I should study that and find that out why in 1967, that's what they decided, the federal government decided President Johnson would sign and make the, it seems very young to me. But
But back
It's 'cause
then,
I'm
if you
older.
died when you were 65.
you know, those things I'm sure went into it,
Sure.
went into the thinking. And what happens too with discrimination laws, states often follow what the feds are doing. You know, like with that, Title VII, that came first and, you know, but then other things happen, like with sexual orientation discrimination, transgender, transsexual, that's gender identity. That's the newest one in Massachusetts. That might never become a protected classification under federal law. It is under Massachusetts law, it is under Rhode Island law. I don't know of a southern state that has that, go figure. But, you know, so anyway, that's a general kind of very broad overview of you know, protected classification and discrimination, and I say it again because sexual harassment actually is a form of gender discrimination. So it was an outgrowth of that law, of the laws that, you know, when they came out were protecting women against things like unequal pay and unequal treatment by men in the workplace. That's where it came out of. And then with a sexual component, being, you know, women being mistreated, you know, based on, you know, on unwelcome sexual advances or comments, etc., stuff that we're going to talk about, and then a whole body of law grew from that. But now it's, you know, I can tell you I've had my cases involving female on male sexual harassment. I tried one of the first male on male sexual harassment cases in Massachusetts back in 1998 when I was, I don't know, 20 years old, whatever. And I've had, it's, you know, female on female, male on male, whatever. So it's not so traditional anymore, and that's not uncommon, right? Times change, things change, and we're seeing it every day, and the laws try to keep up with that, and they do cover that.
They should, right?
Next slide, please. So before we get into sexual harassment, any questions about that or discrimination in general? I mean, just like I'm going to talk about if someone had a complaint of, you know, sexual harassment or concern or illegal harassment, if you felt that there was some illegal discrimination going on, even if it wasn't harassment per se, same thing, we'd want it reported. Like, and I'm going to talk about reporting later, but we'd want to know, management wants to know. It's critical, and we need people to be comfortable, you know, sharing that, and hopefully it's never even, you know, a thought. All right, two types of sexual harassment. One's called quid pro quo, the other one's called hostile environment. Quid pro quo. Anyone want to take a guess? What does that mean? It's Latin. 3 words. This for anybody? That.
That's right.
This for that. So what do you think that means in terms of sexual harassment law?
I'll give you this for that.
Exactly. Who is, you know, who are we talking about, you think?
Management and then the
That's
auditor
right.
position.
Next slide, please. That's right. When an employment decision such as a promotion, compensation, work assignment, performance review, etc., based on an employee's submission to or refusal to submit to demands for sexual or romantic favors, or either as rewards or punishments. So, you know, I don't know, the little hypothetical I used, I'm trying to remember which one I used, but you know, Joe buys this company and he goes, hey, do we have any Joes here, by the way?
Not in
When
this
I got in
room.
trouble.
We don't even
before.
have any Marys
No
left in
Marys,
this
no
room,
Franks?
So go right
All right.
ahead.
All right, well, Joe buys a business and he says to Joanne, hey, welcome to Joe's Pancake Emporium, you know, and I'm so glad you're gonna be I'm sure you're gonna be one of our star waitresses, and we have a whole new benefits program. It's called Date the Owner. And there'll be benefits in it for you. So.
Check, please.
Check please is right, good. So, you know, doesn't have to be this Saturday night, but it's in the next month or so. Tell me what your calendar looks like, because I'd really like to take you out. And if I do, and you go out with me and things work out, you might really be moving up the ladder here at Joe's Pancake Emporium. I'm not sure how high that ladder can be. But
You can work the griddle.
that's right. So, and so that's a classic example, you know, where something good will happen to you, and someone in a position of power and authority has that, you know, ability to do that. Or, you know, well, she really doesn't like Joe, and she really is not interested in Joe. And, you know, Joe says, geez, I'm asking you, you know, I've asked you a few times, I've told you about the benefits program. It's all in this nice glossy brochure I gave you, and you still haven't, you know, given me any dates. I don't know what the problem is, but if you don't get with the program, I hope you like scraping grease off a griddle, because you could be doing that or worse, you know, because we really want everyone here to, you know, listen to the boss. Whatever. The point is, something bad will happen to you. There'll be some punishment if you don't submit to my, you know, wishes as the boss. And obviously, it doesn't have to be an owner. Any person in a position of power and authority, right, is, you know, that could happen with. And so that's quid pro quo. Everyone understand that? I mean, pretty simple to understand. It's the easiest to define, and it is by far the least common form of sexual harassment. And the most common form is, of course, hostile environment sexual harassment. How many of you have heard of that? How many of you just heard hostile environment? I'm in a hostile environment. This is what it came from. And you hear it, and I get calls from, and it spooks people sometimes too. You know, I'll get a call from a client, Jonathan, yeah, this guy just came in my office and he said his boss was really creating a hostile environment for him. And that's, you know, so, because they think of this and they go, oh my God, well really, tell me, what did he say? He said, yeah, he keeps telling him that he's not doing a good job. And he's really not getting his work done on time and well. And he's coming in late, you know. Really? What a bastard. So, and you know, you're doing all, yeah, no, he's right, but I mean still. So, but it's hostile, you know. Now, I'm making a joke of it. Now, there are ways of conveying that information, and maybe he's being a jerk in how he's telling him to do things, right? And we don't want that either, all right? We don't want, you know, we want an inclusive, respectful work environment. We want people to be treated with dignity and respect, regardless of whether it implicates any laws or discrimination or harassment. But sometimes people think of it in terms of, oh, well, anytime I'm not happy with something or my boss is not nice to me, now it's a hostile environment. So that's why you may have heard it. But in this context, it really means something specific. And the definition of hostile environment sexual harassment is verbal or physical conduct of a sexual nature which has the purpose or effect of unreasonably interfering with an individual's ability to work by creating an intimidating, hostile, humiliating, or sexually offensive work environment. Lawyers love to write really long sentences. And I'm one of them, you know, that's a pretty long sentence now that I say it out loud. Why do I have purpose or effect in bold and underlined? Why do you think? Why am I emphasizing that? And pay most attention to the word or.
Because it probably doesn't have to be like a direct thing. You just kind of, yes.
Well, what does purpose mean?
Atmosphere.
Yeah, what does purpose mean?
Well, it means the person might not have been intending to do that.
That's right.
But that's what they created.
Right. Intent is not a required element, as we say in the law, of sexual harassment law, hostile environment, right? So there's certain things you can't be found liable for or guilty of if it's criminal without intent. Murder is a classic one, right? You can't be found guilty of murder, or at least first degree murder, unless you intend to kill the person. harassment, sexual harassment is not, or any illegal harassment, that's not the case. And in fact, most of the time, it's not intended. And when I talk about this and think about harassment, when you think of the word harassment, just harassment, or someone harassing you, what do you think of? What comes to mind?
Just getting on your last nerves.
Yeah, but being, it's not to
Whatever,
me anyway.
Just unwanted, someone,
Yeah, definitely unwanted,
Yeah.
but I think of like something a little bit malicious, like someone out to harass you, to really give you a hard time, purposely try to
Cause
bother you
pain.
in some way,
Confrontation.
hurt you, bother you, offend you, whatever. And it's almost like that word shouldn't even be used in this area of the law. I mean, that's what it's become, and it is that sometimes, and it can be that, but most often isn't that. In fact, most often it's unintentional. The person who's engaging in the conduct doesn't intend to offend or upset, let alone, maliciously bother someone. What do they intend to do often in this area of the law? Make someone laugh. Maybe get a date. Maybe be the attention seeking. Life of the party. That's what they don't intend to really cause harm or bother somebody. So effect is what's key. It's the effect, purpose or effect, of unreasonably interfering with someone's ability to work by creating that environment. We'll break that down more. Let's go to the next slide, please. So when you don't need intent, it means that, what if two people are getting together every day and they're telling each other the dirty joke of the day that they just heard from a friend or they got on the internet, and now you're sitting 10 feet away, man, and you're hearing this, and they don't know that you can hear it, but you hear it. And so they don't intend you to hear it, let alone offend you. But you heard it. What do you do?
Depends.
All right, well, let's say there are two coworkers, neither are supervisors, and you're hearing this every single day. You have to hear this. You come into work and you hear that. What are your choices? Ignore it or report it. And so the question becomes, well, first of all, if it's not even intended for your ears, is it a violation of policy? Could it be? Could it be worse? Could it be, could it actually, under certain circumstances, and I'll talk about it later, be sexual harassment? And the answer is potentially, certainly violation of policy. And you were in that hypothetical a non-target, and in that situation, it's not even like, oh, I know I was saying this to you and I was trying to get you to laugh. It was, no, I didn't even know you could hear it. I didn't even mean for you to hear it. I was doing one of these once and someone raised their hand and said, geez, I used to work at an ad agency. We were all, yeah, everything's cool, man, and just all we're creative, doing our thing, and people wore, cut-offs and Birkenstocks and, whatever it was, and, oh yeah, people in a room just like this with windows had sex on the table, yeah, during the day, but everyone was okay with it. And there was glass so you could see through you walk by. Okay? So, but we weren't offended by it. No one was. It was a small company, and people, didn't care. Well, guess what? I'm gonna go with it still wasn't appropriate. Just, don't have to be a lawyer to guess that, right? And I'm also gonna go with maybe, even if no one was offended by it, and it was inappropriate, maybe the next person you hire is gonna be. But the point that he was trying to make is, well, doesn't it depend on the work environment and the culture? Some companies, are like that, and some are more uptight, and some have, like me, have to wear ties Monday through Thursday, because that's the culture of our firm. Fridays I get to be casual, it's awesome. Sometimes jeans if I pay $5. It's the way we raise money.
We used to do that.
It's good too, it does, it's good to raise money for charity. So, but the point is that no, it doesn't, it can, there's an individual analysis to see if someone was offended or we'll talk about that, but the culture of the place, that doesn't, there's not like, okay, well, if it's this kind of business, then here's what applies. And if it's that kind of business, no. That's not how it works. And the law tries to be, anyway, even-handed. So that's what I mean by non-targets. So, some examples of hostile environment, sexual harassment behavior, sexual jokes or teasing, repeated requests for dates, leering, staring, making sexual gestures, flirting, gifts, calls, notes, comments about body posture, sex life, sexual storytelling, on and on and on. Pictures, emails, internet, photos, jokes, video, objects. I've had cases with, people bringing in objects into the workplace of a sexual nature. Touching. Yeah.
We had that happen here. Somebody, this is years ago, somebody brought in some inappropriately shaped chocolates for somebody.
Yeah.
And the person was insulted and reported it.
Yeah, there's a case that I mentioned in my early ones I'll talk about again about the penis-shaped birthday cake. I had this case, that male-on-male sexual harassment case I had involved one of the pieces of evidence, which I had to photocopy, was a rubber horny toad. And so use your imagination. I won't get into what the horny toad was, but yeah, the plaintiff brought that one in.
Yeah.
The guy who said he was, was claiming to be
It was the cake.
offended.
It was the cake. Like, anybody eat cake? No one eats cake.
Oh, that was from another case that's a big cake a big case in Massachusetts I'm going to talk about. The horny toad case, that was my case.
Oh, okay.
That was a little rubber horny toad, like pet horny toad, like a pet rock, but it was a
Yeah.
little rubber toad with a... Anyway, and that's just one example. But with the internet, I'm seeing, I've had so many cases involving, whether it's emails or YouTube videos or photos or you name it. And that's probably, I would say, a part of almost every case that I have, in some way, shape, or form. Where there's some kind of, whether it's text messaging, instant messaging, and it doesn't have to be necessarily even on the company system. It could be, it's all discoverable in a case, and people kind of think still, even after everything we've heard from, about the NSA and everything else and your policies, that but this is private. Well, we hope it is. But at work, we know, at least we should know, because there's a computer usage policy, that we shouldn't have an expectation of privacy when we're using the company's system, because it's the company's system. We have to be able to monitor things. It doesn't mean someone's there watching everyone's all the time, but we almost have to act as if it is, because there's potential liability for the company. We have to know what's going on. We want to make sure that our system isn't being misused, all that stuff. We do it in our firm, companies, most every company, most every client I know does, but those still I see it. It's amazing, that people think somehow that they're protected. Touching, certainly have had many cases involving where it's more than just what I said, verbal or pictures or emails or whatever, where there's touching of some sort. It doesn't necessarily have to be touching of an intimate body part. I had a case where there's a president of a bank who used to like to give shoulder massages to the female employees. He was an older guy. He thought he was being kind of grandfatherly. It was really kind of creepy. Although I think a couple of the secretaries actually liked it. Still not appropriate. And it made, I don't think, frankly, that it was sexual per se, but he wasn't giving the guys shoulder massages. It was just the women. It wasn't appropriate. And he may not have been, there's a classic example of he may have just been thinking, I'm just trying to relax people. You're trying to relax the female secretaries by giving them shoulder massages, and you're the president of the bank. It's not appropriate. It's not appropriate touching. You don't have to grope someone to say, okay, that's maybe not an appropriate touching. So, next slide, please. But those are just some examples, right? I don't have a list to say, hey, folks, here's the top 100, you can't do any of these things. If you don't do those things, anything else goes. It doesn't work that way. We have this test we apply because human behavior is infinitely creative. And, the facts are different in every case I have, and people are doing, all kinds of stuff. And so we apply this test to see if the law is violated. So I'm going to be talking to you about this, again, the standards of law, but your law is what? There's the law, and then there's your law. What do I mean when I say your law? your policy.
Like where I draw my line, what I allow to happen.
Well, a company.
No,
employee
there's
can-
that too, but no, when I say your law, and that was, in fairness, that wasn't such a good,
Yeah.
I mean the company's law,
Yeah.
that's what I should have
Broker
said.
services
Because you have your
handbook.
law too, you're right, but brokers,
Yeah.
right, broker service marketing, right?
You
That's,
sat for this.
your policies are your law. We don't ever want it to be a situation where we'd be going, oh, geez, you know, there's some judge or jury or someone out there making any of these kinds of decisions where you're, God forbid, ever involved in litigation, any of us. I want to give you some background, you know, of the law in this area, just so you know, but I'm going to keep, you know, repeating it a little bit, is that it's the policy that I need you to be very familiar with and treat as kind of your law, because you can violate policy, inappropriate behavior, without necessarily violating the law and getting to that point. We don't want it to ever get to that point. And we want it to be a, you know, environment where we don't have to, you know, have anyone subjected to any of this type of behavior. So let's break it down. Hostile environment, sexual harassment is verbal or physical behavior in the workplace, which is number 1, sexual in nature, number 2, unwelcome, and number 3, severe and pervasive enough to unreasonably affect a person's ability to work. So that's another way of saying what I said before, breaking it down into those 3 parts. So it's got to be sexual. If it's not sexual, it could be another form of illegal harassment, right? We talked about that before.
Yeah.
Could be, you know, harassment based on one of those protected classifications, or just disrespectful behavior. But it's not going to be sexual harassment. It's got to be unwelcome. And it's got to be severe and pervasive enough to unreasonably affect a person's ability to work. In other words, it's got to be bad enough. Even if you've got, you know, sexual unwelcome, it's still got to get over that last hurdle to violate the law. Could violate policy, could get you in trouble, could result in discipline, all this stuff, but it's not going to violate the law because it's got to be bad enough. And what is bad enough? We'll talk about that. So if I say, okay, it's got to be sexual in nature, usually that's a given. Usually you're not going, oh, well, was it sexual? Was that sexual? Sometimes, you know, it's because you go, is it sexual or is it, I mean, if you ask someone on dates repeatedly, you're not, you know, that's not necessarily saying, I want to have sex with you repeatedly. Maybe that's what it is, but it's definitely, you know, making overtures, right? Romantic overtures, whatever. That's the same, you know, same kind of thing. But usually, if it's sexual in nature, you know it. You know it when you hear it or when you see it. So how about the second part of the test? Welcome. What does that mean? It's got to be unwelcome. Well, there's 2 parts to this test. It's got to be objectively offensive or unwelcome, and subjectively offensive or unwelcome. What do I mean? And unwelcome and offensive, I mean this, basically interchangeable. Objectively means the reasonable person. Subjectively means the complaining party himself or herself. Sincerely, subjectively has to find it offensive. Both of those things have to be satisfied in order to meet this part of the test. So let's talk about the objective part first. Frank approaches Mary and says, hey Mary, that dress looks great on you. Blue really is your color. It brings out your blue eyes. Just like that. Mary falls apart. She's like, this, I've just been sexually harassed. She goes to Pam. She tells Pam. She goes and files a claim at the Rhode Island Human Rights Commission. She's been sexually harassed. And okay, is it sexual? I mean, I would say in that one, I would argue, no. She might say, well, it was a comment about what I was wearing, which is on my body and my eyes. Let's put that aside for a second. Would the reasonable woman, and I'm talking to all of you reasonable ladies in this room, because I'm sure you're all reasonable, would you be offended by that comment? Right? So let's say Mary was really sincerely offended by it. Let's say she's satisfied that subjective part of the test. She'd go no further, because the reasonable woman in her position, and that, just like I described it, would say, I'm not offended. Now, who is the reasonable woman? I know, it sounds like a loaded question for guys. Or a reasonable man. Or a reasonable man. Reasonable person is the standard. Okay? There's no one who gets that job like, you're the designated reasonable person for a year. You're going to get the phone call every time. Reasonable, unreasonable, you know. It is a legal fiction. It's something the law comes up with. It's kind of like a, come on. It's a come on standard. Really? Really? You know? And so all of you are going, I think, right? Really? Really, Mary? So let me change it a little bit. Let's say, Frank goes up to Mary and says, "Hey, Mary. Hey, Mary. That dress looks great on you. Blue is really your color. Have a nice day." What do you think? I said the same exact words.
A little creepy,
Obviously, real creepy.
Creeper.
That's my inner creep. Oh boy, that didn't sound good. Whatever. That's what I was trying to convey. A real creepy guy, and how he said it made all the difference. And that, you know, it makes a difference. And that's why every situation is different. And the way he said it in that situation, I think, may be perceived, even by the reasonable woman as, a little creepy. Let's say Frank goes up to Mary and says, "Hey, Mary, that dress looks great on you, you know, blue is your color." Tuesday, "Hey, Mary, wow, you know, your hair looks great today." Wednesday, "Hey, Mary, wow, super shoes." "Love your accessories." Well, maybe the guy's a budding fashionista. I don't know. Maybe he's a frustrated, you know, loves reading Vogue and is into, or maybe he's a creep. So, you know, that pattern kind of, right? How about this? Frank goes up to Mary and says, "Hey, Mary, that dress really looks nice on you. Blue is really your color. Oh, and it also really accentuates your large breasts."
Oh.
That was just a joke.
All right, so I'm going to ask the same question. Let's say Mary is subjectively offended. Maybe she's not subjectively offended. How about reasonable woman? What would you say in that situation?
Probably offended.
Yeah.
And you're not even a reasonable woman. You're not even an unreasonable
I'm
woman.
offended.
But you're offended. And that's why I mean, that reasonable you know what? And you're right, though. It's the reasonable person. I hope everyone
Yeah, the reasonable.
would find that offensive, not just the reasonable woman. You know? And by the way, there may be a person out there who says, "I don't know, what's Frank look like?"
I'm telling you.
What is, how much does he make? What is his position with the company and when can I meet him? I've heard that doing these before. I have. And that's the wrong answer. So, okay. Now, with that individual, and if Frank had really said that to her, she might not be offended by it. But the point is, it would violate policy big time. The reasonable woman, I would say, would be offended by it, and we can't have it. So, everyone get that as far as the welcomeness part of it? All right. So, let's talk about that though, just because I've now suggested that as far as the subjective part of it, herself or himself. Next slide, please. So, there's this case, and I'm sure there are in Rhode Island too, but the key case in Massachusetts involves a woman who worked for a bus company, and she worked with a bunch of guys who made sexual comments and told sexual jokes and storytelling and all this other stuff. And she filed a lawsuit for sexual harassment, and the court said, stuff's really bad. You know, let's apply the test. Sexual, yep, check that off. Would it have offended the reasonable woman? And this woman, Jill, her name was Jill Ramsdell, would it have affected a reasonable person in her position? Yes. We don't think it really offended you. What do you mean? I'm suing. Why would I sue if I wasn't offended? Why would anyone sue if they really didn't feel like they were harmed? Money, maybe? I see it every day. So they said, no, we don't believe you were really offended, Jill, because we have a mountain of evidence that you were an active participant in the same kind of behavior. You know, like when you brought the birthday cake shaped like a penis into work. That one, that's that case. And on and on and on and
I feel
on.
like you kind of set yourself up for that though, like that environment. Like you're the only woman with all those men. What do you think's gonna happen? Talking about race cars and football, like no.
Right. But it's interesting though, when it's funny when I'm doing these things, when someone says that, often it's women who say that. Who say, you know, come on, really, like have some, you know. And I understand that, and and I understand where you're coming from, and I think it's reasonable and fair for you to say that. But I would argue that you should be able to be the only woman or conversely, the only man, whatever, and not have to worry about dealing with that. It shouldn't be like, like if you go to work at a adult bookstore, movie store, whatever, and you're gonna claim that you're surrounded by sex all the time, you got a problem with your case, and you shouldn't have gone there.
Yeah.
All right? I had a client that made ovulation kits, and they had a call center, okay, and they had calls, you know, all right, so if I stand on my head, count to 10, blah, 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 will I have a boy? You know, while we're having sex, those are the questions they would get. And if you walk through the call center, you're gonna hear that stuff. Well, you know going in, or you should, you're gonna hear that stuff if you walk through the call center or you're there. That's different than just because I'm a woman, you know, I should be, or, you know, whatever. I should have to just put up with it and go, yeah, I know, well, it's rough, it's a bus company, you shouldn't have to.
No, I'm not saying that, I'm just saying like.
Yeah, no, I
what do
know,
you think?
but I just wanted to use that to make that point, and that's what's difficult, and frankly, that's where these laws came out of, is that, hey, you know, toughen up, right? You know, you're gonna have to, well, in her case, there was no problem with her being one of the
Yeah.
participants. She was, in a big way. Now, what if that case, which this didn't happen, but let me just change the facts, hypothetically, the guys would pat her on the rear end and rub up against her and stuff like that. When she was bringing in the cake and making the sexual jokes and talking about what great sex she had over the weekend and all that stuff, what then? Does she win that case?
Probably.
Probably, right? Because of the physical touching, that's a whole other level. Just because she was, you know, engaging in that sexual banter or whatever doesn't mean that she, okay, open season, that's it, anything goes. She might lose a case based on this complaint, but not on that complaint. That wasn't that case, but that probably would have been, you know, it would have been a different result. She did lose, it was dismissed. Next slide, please.
Interesting.
All right, so it's got to be sexual, it's got to be unwelcome, objectively and subjectively, and finally it's got to be pervasive and or severe enough to unreasonably interfere with someone's ability to work. And generally speaking, the more frequent the conduct, the less severe each incident needs to be. So, you know, if Frank made that comment about Mary's breasts one time, would it violate your policy? One time. Yeah, definitely would. And that's what we have to be concerned with. Would it violate the law? No way. And you might say, that doesn't seem right. But it's, I say no way, you never know, right, what could happen. But based on, there's a good body of case law now and everything else, it wouldn't meet this last part of it. It wouldn't be bad enough to unreasonably interfere with someone's ability to do the job. And the reason that part of it's here is because there's, you know, the law wants to put some regulator on this, you know, so it's not like, oh, geez, one comment, God, oh, I can't work anymore, I'm going on disability, that's it. You know, it's like, now, this person may really have been affected, might be very hypersensitive, and there's this thing in the law you learn about in law school, take the victim as you find them, or take the plaintiff as you find them, but this is what kind of counterbalances that, where it's, you know, it's gotta be, you know, at a certain level that's bad enough that we're gonna say, you know what, there's liability here. Because you can not like, you know, working somewhere, we don't want this to happen, violate, you know, policy could be violated, you could leave if you don't like working there. But for it to be bad enough for you to have a claim, you know, that's that hurdle. Again, that's not what we want to keep in mind when we're going about our business every day and the policy, but it's just something to understand with this part of the test. So, you know, Frank says to Mary, wow, you know, dress shows off your breasts, whatever, one time. Would it do it? No. Two times? 3 times? 10 times? What would it have to be? There is no, again, there's no like correct answer on this, and different, you know, the Rhode Island Human Rights Commission is going to see it maybe differently than this jury.
I'm
someday.
sorry, you said correct answer
Number.
to what would happen in the workplace?
No,
or
how
what-
many times would violate the law? How many times
The
would it have to
law.
occur to violate the law?
But here, we could say 3 times.
No, here you can say none.
Okay, well, I'm just.
No, right, exactly. I'm talking
just-
about legal standards.
Okay.
Yeah, I'm talking about just so you have an understanding of the law behind all this, but we don't ever want it to happen, not even
Right.
once.
No, I'm saying because where I used to work, if it happened, they would pull the person in, talk to them about it, but having
Oh,
to get that
okay.
type of, there was
Keep
some
that in
kind of-
mind when we talk about
Okay,
discipline.
all right.
Keep that in mind, don't forget.
Okay.
I won't forget.
All right.
So, because that's not, I see what you're saying, but that's
Okay.
not what I'm talking
Okay.
about in terms of violating the law, right? So the point is, there is no exact right answer, and I've seen different cases, and I've made these arguments. Well, Your Honor, look, in Jones versus so-and-so, this happened, 3 times, and then a month went by, and then it happened once, and then another 5 months went by and it happened again, and the court in that case said that wasn't severe and pervasive enough. In our case, it only happened once here, once 3 months later, and once 2 years after that. There's no way, if it was not, severe enough. In this case, it would be that's what lawyers do, right? You make these kind of arguments based on past cases. But there's no exactly, and that particular judge or that particular jury on that day, so that's why it's not, this is far from an exact science, but that's the thinking behind it. But the more severe each incident is, the less frequent it needs to be to get over that hurdle. One touching, Frank, instead of commenting on Mary's breasts, goes out and grabs him. Sexual assault. All right, I had a woman call me once who was raped by her supervisor on the night shift. Once. Does it take more than that? Well, obviously, that's rape, that's criminal, but it's also the most severe form of sexual harassment. So sexual harassment, you can get a comment, off-color joke, sexual comment, whatever, and then think of it like a spectrum, all the way to rape or sexual assault and everything in between. And so that's why each situation needs to be evaluated, on its own. That's what we do with applying these tests, and then juries or, hearing officers or judges make the decisions. I'll tell you who doesn't make the decisions, the people who are involved in it. They're just subject to someone else's decision, and again, it's far from perfect. So, and then just I'll say quickly, as far as this part of the test goes, just like the welcome, whether it's unwelcome or not, it's both subjective and objective. Both have to be met. So, you make that comment, and yep, it was sexual, yes, it was offensive, and would have been to the reasonable person in his or her shoes, and was to the complaining party. But was it so bad that you couldn't? It really interfered with your ability to work. It really got you there. It really caused you to go out on leave or go on. I had a case, go on disability. In this case, I had a male-on-male case in the 90s. The guy said, "This guy's harassing me. It caused him to go out on disability, and I tried to kill myself twice." That was the evidence. So we tried to say, subjectively you may say that, but the reasonable person, based on these comments that this guy said, wouldn't have made the reasonable person have to go out on disability and interfere with their employment so much. Problem is when you have evidence like that, right? Guy tried to kill himself. That was an interesting case that I could go on. Pam's already heard it. I could go on and on. I could write about a book about this someday, but it had a little of everything in it, and arguing about all these standards. And one of them was really we focused not on that, on the reasonableness, but the subjective part of it. Because we said this guy who was married and had a kid, who was claiming this homosexual coworker, non-manager's coworker, was making sexual overtures to him that were unwelcome at work, and he complained, and the company didn't do enough. It took too long for the company to respond, and then, the guy was ultimately fired. But lawsuit filed, and we said, how could he be, and think about the subjective standard as far as the active participant, how could he be offended by sexual comments that this guy was making? Comments when he had sex with him 9 times after work.
Wait, so this guy's married to kids?
Yeah.
Okay.
Oh yeah, you heard me. Now, the guy denied that and said the alleged harasser was lying. Until I die, I will believe
He's not.
the harasser. Absolutely. And he wrote these dates down every time. And his way of keeping a diary, he didn't write a whole diary, but he would write, they were so meaningful to him, this guy who was gay,
Yeah.
that he would write the dates down in a pen. He said, I wrote them down on the day or the day after we had our encounters. And I had a little piece of paper. There was evidence in the case. This is how involved this case got. The plaintiff's lawyer,
Who did you represent? I'm sorry. Just
company,
okay.
company. the plaintiff's lawyer got this piece of paper and involved an ink, you ready for this? Ink dating expert. And what they do with ink dating is they take a tiny pin-sized hole, they go, and I think this is stupid, they go into the ink, I think they were all written in pen of some sort.
Like carbon dater or
They
something?
pull it out, it's like that, it's like carbon dating.
Some
And what
CSI
they do
shit,
is
maybe?
they send it to some special lab where they can say, here's when that ink was made, here's how long it was, it dried, and here's, the year it was made, all this other stuff.
Crazy.
I cross-examined the expert. I thought I did it right. I don't think that's why we lost the case. I think that we lost the case because the person he complained to first, who was a quasi-supervisor, well, not really a supervisor, he was like a working foreman, didn't bring it up the chain. Didn't report it, took too long. And then, when I got him on the stand, he had, how people, you talk to some people and they have like a nervous habit, maybe they're telling you something sad, but they're smiling, but they're not really smiling, they're not really happy, but they're kind of just, it's like a nervous thing. Yeah, my dog was run over yesterday and stuff, yeah, crushed all over the sidewalk. Yeah, it was a mess. He was testifying, and he was taking it seriously, but he was nervous as hell. And he had this smile, like plastered on his face. And the break came, I said, Alan, the jury's watching you when you're talking about this serious stuff. You're smiling. And he said, oh my God, I am. All right, don't worry. After the break, I'm going to get back on. It'll be fine. Don't worry. It better be. It looks really bad. So he gets on. Guess what?
Smile.
He starts smirking again. And I know it's like a nervous tick, and he can't help it. And I can't, right, in the middle of his testimony, we can't say,
Yeah.
what do you, Mr. Smith, what do you think is so funny? I'm not gonna do that. We're lucky the other lawyer didn't do it, but to me, that more than anything, made a bad impression. We don't know, you can't interview investors, you can't interview jurors afterwards. I think that was devastating. Because what it did to the jury is they looked at it and went, this company really didn't take it very seriously.
Yeah.
In fact, they did once it went up the chain of command. But anyway, fascinating case that had a little bit of everything. That's my little, yeah, kind of cool, right? TV movie at least?
That's like Law and
Straight to
Order.
Netflix? Yeah, I don't know, someday.
Criminal Minds.
That's
All right.
intense.
Yeah, it's that kind of, it was
That was
very interesting. It had everything, including that rubber horny toad. All right, other situations, office romance, what about that? Is that sexual harassment per se? Two people are going out of work and it's welcome, it's consensual, it's all, whatever? Is that, what do you think, sexual harassment? Anyone here not know of, anyone never been in a workplace where people are dating?
It's frowned upon.
Not me. Yeah, I mean, it's often frowned upon. There are fraternization policies that companies
had-
have.
Yeah, Chris, is this harassment?
We had a situation, Crystal was dating somebody who worked here. They weren't dating when they worked, when they started, either, that they met here. Well, they went to high school together, but it was when they met here. But it was, so yeah, that we've had that happen here. That's
Yeah.
all I'm
Would
saying.
that work? Sometimes it doesn't work and then it goes bad.
I know, but it did.
Right.
Well, I know, I'm
So-
just saying, like,
So it wasn't sexual, there was nothing harassing about it, right?
Right.
Joe didn't harass you,
No.
because we'd have to beat the shit.
So,
Oh, that's harassment.
put the Vaseline
none
on
of it's
his desk.
deserved, no. So, yeah, I mean, just by virtue of the fact that the relationship exists, doesn't mean it can exist as long as it doesn't interfere with stuff. So for starters, when I see the problems, it's supervisor dating non-supervisor, and now, people, he reports to her, right, and they're sleeping together, right, and I'm not, and let me do the math. Let's see, I think maybe he's gonna beat me out for that promotion. Just a guess, that's kind of but it means that's when there are issues, right? Is when there's this favoritism or perceived favoritism. We don't even want that. We want people feeling like you're going to get a fair shake. So when it can become sexual harassment it was fine until good loving gone bad. And someone says, you know what, I'm done with you, I don't want to have anything to do with you, and the other person could see him every day at work. Oh, come on. don't you wanna go out with me one more time? Come on, please, please. Just one more time. You know, no. All right? The restraining order wasn't enough to send a message? No. I'm joking a little bit. I just had a case, actually, where, you ready for this? The judges there's some judges that are nimwits. And this judge issued a restraining order of 10 feet. I swear to God, 10 feet. I had a call from my client saying, we got 2 people who work, really, 2 people who work here, and this was like, do you remember the movie Fatal Attraction? She was not well. And I'm serious when I say that, she was not well.
Did she bring dead bunnies in?
Yeah.
She didn't cook any rabbits, but this was a recent one too. I'm trying to think. His mother committed suicide a year ago. And on the 1-year anniversary, which was recent, they found a note on her computer. That was a note written, an anonymous wrote, "I killed your mother."
Oh my God, it's terrible.
You know, his car got keyed. He had a restraining order because of that. But they're both still working there. So, and needless to say, when my client found the note, she's gone. You know, but that was really, but a 10-foot restraining order in the workplace, it's not really gonna, you know, probably achieve what you need it to.
I wonder why
So-
like I heard that, something like that. No.
No, it didn't go public.
Okay.
This was a private thing. It was pretty recent though.
They
But
wouldn't like let someone go. They would actually go through with that restraining order. I'm just curious. Like they wouldn't say, "Hey, look, you're
well, the
fired."
the person got a restraining order. There was no issue between them for a while after they broke up, but she had kind of a breakdown, and then they found the note, and it was not good. So that was enough to say this ain't gonna work. Obviously, she's got mental illness, right? So, but in any event, that's how it could become sexual harassment, right? If one party's saying, I don't want to, and then it persists, and so it's just something, it's most important to just be aware of those situations and know what, if there are parameters that need to be put in place. All right, parties, events outside of work. What do you think of company parties where alcohol is served? You guys, I know you've never had one, but if you had one, and alcohol was served and people drank and danced and had fun and people engaged in conduct that was inappropriate, and let's see, what have I seen at office parties I've been at? Grinding. That's what the kids call it these days.
Hey, whenever I was in school, we room for the Holy Spirit. Sounds Catholic school.
Did you go to Catholic school? Oh, really? Yeah.
And then they walk around.
That's what I said to you?
Yeah, they room for the Holy Spirit.
That's great.
Yeah, they're very, we didn't, so they didn't call it grinding. I mean, slow dancing, whatever, but
They room for the
now
Holy
it's
Spirit.
like, I have kids in high school now in college. I mean, it's like, oh, Dad, they're getting together, grinding. Well, okay. What are they grinding? What are they?
What aren't they
manufacturing?
Sorry.
I missed it. You have to share that later. But I've seen that with adults at office. I mean, the stuff that's inappropriate, and when that happens, the company needs to respond, and there can be, violation of policy. There could be potential liability, whatever. Why? It's offsite, after hours, holiday party, not at work. It's workplace sexual harassment. Isn't that what we're talking about? Well, no, not necessarily. Right? It's a company-sponsored event. Same rules apply. You gotta be responsible. You're gonna be held accountable. You can have fun. There's plenty you can do without crossing the line. How about drinks after work? Let's say a few employees go out for drinks after work, and you got one employee, Frank, he's never had vodka before, and wow, this Grey Goose is really good. And he puts down about 12 shots, and now he's not shy anymore. Frank's a big guy, he can handle it. And Mary's next to him, and he's had a crush on Mary now for the past 3 years. They've worked together, and he gets brave, and he starts saying, "Hey, Mary, do you remember, I used this for Joe Namath, do you remember that video when he was drunk on the sidelines, and this, female reporter, "Can I kiss you?" It's like, "No, Joe, you can't." And let's say that happens, right? And it's, it goes on, and Mary says, "Hey, we got a good work relationship, you're now kind of threatening that because you're acting like a jerk and you're drunk, and stop doing this. And she gets up to go away, and he grabs her rear end and pulls her back in, and now she is completely devastated, upset, has trouble sleeping, is a wreck the next day, goes into Pam and says, Pam, I was out with, Bob from Account Temps? or Joe from Account Temps, or whoever, yeah. No, except not Account Temps, he works here. Joe from Accounting. Well, this is what happened. Or Frank, or whatever name I used, I can't remember anymore. And so now Pam has to say, what do I do with this guy? Do I do anything? Because she just told me about this situation. She said she can't think straight, let alone do her job. What do I do? Maybe I call Jonathan. Let him decide. But no, that's right, because, we did this training. No, I'm going to decide. I'm going to, what?
Can we ask her? What would you do?
No,
Oh.
you may not.
She was so
You have to
serious.
answer.
I don't know, I
You're
don't know.
Pam.
That's what I'm
I know what
saying.
I would do.
I don't know.
No,
I
it's
don't
What do
know.
you think? But what do you think? That's a question. What do you think would be?
Is this where you draw the line and where Pam says, you know what? I can't police everyone's personal behavior all the time. You're big boys and girls, okay?
Yeah, it wasn't a
That's what I would
company
say.
All right,
thing.
if it happens
We're just
again,
out
if it happens here, come and talk to me,
Right.
and believe me, I'll address it.
Don't
but-
go out with
But
him
not
again.
now. Yeah, and you may not want to go out with him,
Yeah.
It's a motherly advice.
Good idea.
right? That's choice A.
Yeah.
Choice B is Pam gets involved.
Yeah, you have to talk to them, ask.
What
All right.
do you think I should do? I'll tell you.
How many,
what I
I'm
would
gonna take a
I don't think
vote.
you should get involved.
How many people, and you gotta vote, don't be keeping your hands down,
Don't be
abstaining
shy,
from the vote
you
like
have to
Florida
vote.
in 19, whatever that was,
Yeah.
2000.
Florida gets such a bad rap.
Well, deserved. All right, who thinks Pam, this is where she draws the line, not yet? Raise your hand if it's choice A, she's not gonna talk to this guy.
Don't be shy.
Don't be shy.
She's not gonna talk to
Not
you?
gonna talk to him,
I'll
not
do
yet,
two.
okay? And who's voting the other way? Everyone else. All right.
Alright. That's exactly what I would do.
50-50.
I would talk to him. You can't, because there are times when by having a conversation with somebody and bringing something like that to somebody's attention, it can make the difference between somebody stopping and saying, you're right, I should have known better. Because otherwise you can have a problem that can just snowball out of control because you think, it was innocent. But when somebody is truly bothered and it affects their work, it's something that work has to deal with.
I feel like
And
it
what
was-
did she say
I
that
feel like
made
it's
you
almost out of
think
your
that?
hands though. You know what I mean? Like if I was out with somebody from work and somebody like
Yeah, that's
inappropriately
your-
did something to me, I would address that person
Well, if-
or I would just stay away from that person. And if it happened at work, then I feel like you should come in.
But
you
what
know?
if it was, but you said that it was affecting your job, you couldn't do your job because of it?
That's the key here.
That's the key.
Yeah, that's kind of the
If
key, I
it's,
guess.
if it's
yeah.
something that happens
I don't
on
know,
your
that's a
own
tough
personal
situation.
time, and, it's no big deal, you come in and you can still get your job done, but,
Right.
you come in, you're being rude to people on the phone when they call in, you're very jittery, you can't sit still for long enough, and
Yeah.
somebody says, what the heck's going on with Ashley, her work performance is atrocious, and this is getting out of control, all right, well,
Yeah.
Yeah, I
nobody
can
knows. So I mean, and the other thing too is that the person who, sometimes people don't see how their behavior affects other people. And it seems to me like it's all of our jobs to make sure that we're, objective and that we're trying to do the right thing. And I think you can easily avoid problems when you try to deal with them right away as opposed to letting them
Yeah,
kind of fester.
Exactly. And the thing is that it's in her, I don't want to say power, but ability to have a talk with this guy. If this were Joe Schmo off the street,
Yeah, you would.
or a boyfriend who works somewhere, whatever, right?
Right.
No, Pam might say, look, she might give you some advice on what you should do, but she's not gonna go find the guy.
No.
She might wanna find the guy and kick his ass,
If I could,
but she's
I
not
would.
gonna do that. So, but with this guy who works for us, always, I would say, have a talk. I didn't say, bring him in, take him to the woodshed,
Right.
beat him to a pulp, and then fire him after you beat him up. I said, have a talk
Right.
with him. Say, hey, dude, and it doesn't mean, I don't mean, it should be documented and all that, but you need to know what we were told. And I don't want to get into the whole investigation thing here, but let's just say he says, this second I did it and I saw her walk out, I knew it. I feel so bad. I was gonna apologize, but I'm too like, I don't know what to say to her. I'm like, it's too, and I saw her and I can't even look at her right now. I feel so bad. Pam, tell me what I should do. I want to apologize to her. You know, will she sit down with me and let me apologize? And maybe she will, and maybe you work it out that way, and you know, every lesson learned and all that. But you know, or it could turn out that more comes out of it, of an investigation, and more. You know, you never know. What I don't think Pam should do is ignore it. You know, even in that situation, of
Good
course,
job,
it's a
Pam.
harder one than if it happened at work, in the workplace, or if it happened at a work event. I know it's a little bit more, you know, challenging, controversial, whatever, but that's my view, that's my advice. Next slide, please. Management responsibilities. Managers have certain responsibilities when it comes to this area of the law. It can't be ignored. That's perfect, just what I was saying. I mean, it needs to be addressed on some level. You know, there are people that, you know, oh yeah, so-and-so's like this, or, you know, whatever. We know that person to be that way. Don't worry about it, no big deal, you know, just ignore it, or whatever. But that's not, you know, an appropriate response. The response should be, if a manager knows about it, hears about it, whatever, report it up the chain. And the chain is really, we don't have a long chain here. The chain is, we got Pam, we got Eric, we got two people who are, and Eric's not in the, he'll be in the new policy. Those are the go-to people. And if you're not comfortable going to them, go to David Greenberg, go to another member of management, whatever. There are avenues of, you know, redress here, which you can, you know, bring these issues to, because management wants to know, so it can be addressed. And managers are expected to address it, even on site, if they see it, if they can. And as I said, report it. And if there are issues then, that go beyond and it becomes something else, that's when I get involved often. Next slide. So, I'll again reiterate with the policy as far as your law, you know. It doesn't have to constitute a violation of sexual harassment law or of other illegal harassment law, and still may be inappropriate behavior, still might violate your policy. And you know, it's not just about avoid legal claims. It's let's have a environment, a work environment that people are comfortable coming to every day. Next slide. How about non-employees? You know, this happens, you know, where, and I've seen it in law firms too, where, you know, female, I've seen it with, you know, I remember a situation, older client, a guy, young female secretary, hey baby, you know, how you doing, honey? You know, he doesn't mean anything by it, but he's the client. The client's always right? We can't address it with a client. We want the business. Is there a client exception? Is there a client exception to sexual harassment law?
No.
Or customer? No way. Can it be a more difficult situation? And probably all of you have had any client, right? And I have clients, you know, yeah, I could see that person saying that, or that person did say that. That person regularly says that. And you know, you need to report it. You need, you know, and what's nice is you report it to management, and you know, so you don't have to address it directly. Now, do you have to? You know, can someone bring a claim either to management or go file it, whatever, unless they first tell the person who's the harasser to stop? Is that required before you can kind of pass go and do other stuff? No, why not?
I'm sorry, you said.
Why? Yeah. Why isn't it that? Isn't it only fair that, like when I said, you know, if you're sitting there and you're hearing these two people tell jokes every day, shouldn't you have to, you know, go and complain to management before you know, go and file a complaint or something with
They
it?
probably
You
get
know,
uncomfortable and they don't want to say anything, or maybe embarrassed. I don't know.
well, you want
Not
to give
so
the
far
person a chance
embarrassed,
to, you know,
Yeah, but
address
they
it.
could be scared.
Yeah,
too.
it's
Why?
different.
But I mean, you're supposed to say like that, you know, I'm hearing that, and I have been in situations where I'm hearing things, I'm like, really? And I'll just walk out the door, like, I'm here, really, I'm here.
Oh, we know you're there.
I've done that before, I've gone, I'm here, and then I'll leave. But I've never had to go to.
So you're right. Encouraged, yes. Required, no. For that reason. First of all, people that are not don't wanna like have that confrontation. I'm a litigator for crying out loud, and I'm non-confrontational. I don't like to, you know what I mean, for getting to personal, you know, when I don't like having to, you really wanna get in this personal fight with my opposing, well, fine, let's go, you know. But it's not a comfortable thing to tell someone they're doing something wrong, whether it's a performance evaluation if you're or telling them that they just said something that offends you. It's not an easy thing to do. The other thing is, what if it's a manager you're concerned with? I don't know, I don't want there to be any negative repercussions, whatever. The point is that if you can say something, great, because often, guess what, as we talked about before, it's not intended. No one intended to offend, harass, whatever. Oh my God, I'm so sorry. Oh, you'll never hear me say it again. I am so sorry. And that's all it takes, and done. But not required because of those reasons. You know, someone might not feel comfortable, they feel more comfortable talking to Pam about it, and then there's a discussion, and there's a reminder about non-retaliation, and hopefully it's addressed in the right way. So, getting back to this, yes, third parties, whether it doesn't have to be an employee, contractor, vendor, customer, client, whatever. And it goes both ways, by the way, right? We don't want our employees engaging in, you know, inappropriate conduct towards those other third parties. Next slide, retaliation, I just touched on that. You know, this is a whole separate area of the law and of the policy for a reason. And that is because, you know, there may be a complaint and maybe there was conduct that doesn't rise to the level of sexual harassment like we were talking about before. But someone, you know, out there goes, you know, and there's Joe's Pancake Emporium or whoever it right, and goes, you know, she filed a claim against me at the Rhode Island Human Rights Commission. She's not going to be the head waitress. She's not even going to work here anymore. And I'm going to find a way to fire her. I'll tell her she's just not doing a good job, you know, and that's classic retaliation, right? But it can be less, you know, it can be in more subtle forms too. And it doesn't have to be filing a complaint or whatever it could be. You know, I participated in an investigation, or I raised this particular issue about discrimination or whatever. So that's something that, you know, the law and we at this company and my clients want people to feel comfortable coming forward and feel like you can come forward. We know it's difficult to, but you don't have to feel like you could be retaliated against for coming forward. It doesn't mean that, oh, now you get a golden ticket, okay, and you can do anything, and you could be a bad performer or be a jerk yourself or whatever, and you're golden. No, you can still be, but not because you did this, not because you brought it to management's attention. And speaking of which, by the way, I've heard this. Well, Jonathan, no, we didn't investigate that because she didn't want to make a formal complaint. It's like, what is it, CSI? Mm-hmm. What's a formal complaint? You know, it's a report. It's information that was given. There's no such thing as a formal complaint unless you're talking about court or something. It's information received. You don't have to make a formal complaint. What if someone says to a manager, you all, let's say you're all managers right now, you have to make this decision just like the other one with Pam, and I go up to you and I say, look, I'm going to tell you that this happened and what he did to me, but I don't want you to say anything. And you know I have privacy rights and all that, and I'm asking you to respect my privacy. But he did X, Y, and Z to me, and he said that. And so I'm telling you because I gotta get up, and we've worked together for a long time, and you know, we're friends and all that, but I need you to take your manager hat off. Please don't report it. If it gets, like, I promise you, if it happens again, I'll absolutely go tell Pam. Otherwise, not yet. Okay? Agreed? Deal? Or no deal?
No deal.
No deal! Good.
Girl, I'm Amanda.
No deal, she did that.
I did.
Everyone agree with that? No deal? No deal. I had that happen, and it, you know, once with the HR manager. It was HR manager. Woman comes in and says, let me tell you what happened. This is what Rich did to me. Blah, 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 blah. Don't tell anyone. And I know you're the HR manager, so I will write a note. You can put it in my file. It says, I'm going to sign it. It says, you do not have to investigate this report. And you know what the HR manager said?
No deal.
Oh, she said deal.
Yeah,
She did?
Oh, yeah. She said, well, all right.
Well, she put it in the.
Great.
because less work for her.
Oh, yeah, she kept, you know, but guess what happened? It happened again. And guess what else? he was doing it to other women. And it wasn't investigated, because this HR manager, dum-de-dum, said, oh, I got a note in the file. That note would not get, that's worthless. Worthless, except, you try to say, oh, it showed that she wasn't really that offended by it, or whatever. Well, that doesn't help you now. Okay, and fortunately, she finally came through again, came forward again, and it turned out that, when they did the investigation, other people were affected, and he was gone. And it didn't become a problem, and they lived happily ever after. But the point is that people need to realize once management is informed, then there's an obligation. And we want management informed of inappropriate stuff. All right, next slide, please. Investigation and response. I don't have to get too into this, but these are just kind of the steps that the people who are in charge of investigating these things go through. As far as interviewing, I already talked about formal complaint, no such thing. The alleged wrongdoer is going to be interviewed. Non-retaliation is going to be emphasized. Any witnesses are going to be interviewed. Document the investigation. Reach a conclusion, which almost always you can. Not always. Sometimes it's hard. It's a he said, she said, or she said, whatever. But often it's like, geez, we got this evidence right here, like all these emails and photos and, you name it. Or admissions, because people, again, didn't mean to harass or offend. They say, I did do that. I feel bad about it, but yeah, I did it. But still, doesn't mean that there isn't a policy violation. And then there's a report and then action taken if there's a policy violation that's found. And what should that be? And this gets us all the way to what you were saying as far as the 3 times. And I think what you were talking about is like progressive discipline.
Mm-hmm.
Like if you do anything, okay, you were absent today, 1 strike. You get a verbal warning, and then your absences continue. We're going to give you a written warning, and now it's going to be a final written warning, and that's progressive discipline, which is what most companies do. What I was talking about is just in terms of what would violate the law, and in terms of figuring out, if we get up the next slide, what to do in a case where you find someone's violated your sexual harassment policy or protected classification policy. What should that discipline be? Well, it was the first time. Does that make a difference? Maybe.
Depending on what it is, right?
Thank you.
And then you have.
Exactly. So what if it depends on the severity of it? Maybe that one time, that one comment, I don't care if it would violate the law. You violated our law, and we're going to give you the most severe form of discipline. Maybe in whatever circumstances there are, we think, I think a written warning would be appropriate. 1 more strike and you're out. Usually it's not more than that, for a violation of a sexual harassment policy. And also, we just 3 months ago went through this with this person, and we disciplined them, and now they're doing it again. And it may not be a huge infraction here, but it's their second, and they so terminated. So it depends on, all of those things.
Because I know we had someone that was a swinger and he was recruiting.
Mm.
And that's what happened to him.
You did?
No, my last.
Recruiting, I like that.
And then they let him go.
Where'd you walk,
Because
Barry?
he I'm not
Yeah, let's talk
there was
afterwards,
a lot of
because I
stuff.
could get some business from that.
Yeah.
swinger.
He was
Recruiting for swingers.
That's great.
There was a swinger in our town, and about a month ago, a dead guy was found in her pool in the middle of October.
Oh, jeez.
What time?
Dun dun dun. I
What
can't tell
time?
you. No, okay. Westboro, Westboro, Massachusetts.
She's gonna look it up.
So
It's like
it's still a
that.
mystery. No one's saying what. It's not like they're
Investigation.
not saying it was a homicide or anything. But what was she doing there? What was he doing there? Well, we know. We don't know what he was doing with his clothes on in the pool in the middle of the day in October.
Nice hot October.
But hey. So anyway, to conclude, well, strange note to conclude on. Don't go there. A lot of this is common sense, and I talked about all the law stuff. Just like I did in law school. I'm like, oh my God, this is too much info. But really, as far as the basics of this and just behaving at work or outside of the work, as the case may be, a lot of it is common sense. It's thinking before you say or write something that you're gonna maybe regret. And we are in this world right now where this is, right? I mean, I'm too addicted to this thing now. And everything is instant, and clients expect instant, responses. And we're used to just talking fast and being fast and multitasking and and along the way, that's when I see mistakes made. It's just like you got a lot of work to do and you get so much and you're doing it all, but then you made 10 spelling mistakes you wouldn't have made if you just slowed down.
Mhm.
So kind of think of it like that, where we're moving so fast that sometimes we don't think things through. Not just this kind of stuff, any kind of stuff. And you send that email, you make that comment, you say that joke, you whatever. And humor is a big thing. It's a big thing for me. I mean, I think everyone's too serious these days, but at the same time, you got to balance that with, hey, don't kill the messenger, but we have certain guidelines and we have to act accordingly. So if you have any question, if that little voice in your head's saying, because if you wait that little bit of extra time so you can hear that voice and you listen, the voice is probably right. You probably know, don't hit send, don't make that comment, don't make that joke, don't, whatever. And hopefully, you'll never have to deal with lawyers for any of this kind of stuff, ever. And that's about it. So thank you very much for listening and being a good group. Any final questions before we end?
Julie, any questions from you?
No, no,
All right.
Thanks, Julie.
Thanks, Julie.
thank you.
Bye.
All right, everybody.